Sir, law students learn early that the separation of powers between the executive, legislature, and judiciary is the foundation of the rule of law. As such, I hope the House will agree with me that Parliament, as the primary organ of the legislative branch, must not only be able to discharge its lawmaking responsibilities, but also to ensure that the government remains faithful to its duty to all Singaporeans. Sir, to this end, I wish to reflect on my nearly 20 years in this House and highlight 3 areas where I believe we need to do better. First, on the way parliamentary questions are managed. Second, on Parliament's reputation as a lawmaking institution. And lastly, on the Presidential Council for Minority Rights, which is a vital safeguard on Parliament. First, on parliamentary questions or PQs. PQs are a critical aspect of government accountability, as they are the primary means by which MPs can scrutinise the government's performance, as well as to reflect the concerns that are brought to us by our constituents. To that end, it is notable that questions posed by MPs to one ministry may be redirected to be answered by another ministry without prior reference to the MP. From my understanding, such redirection is done by the government ministries and not the parliamentary staff. Of course, sometimes the redirection is justified, such as when the MP may have inadvertently asked the question to the wrong ministry. For example, questions about banks may be mistakenly filed with the Ministry of Finance when the bank regulator, the Monetary Authority, comes within the province of the Prime Minister's office. However, it seems to me that questions may also be redirected simply because the government finds it expedient to do so. This may undermine the main purpose of question time, government accountability. To take a recent example, the leader of the opposition had in August last year filed a PQ to the Ministry of Transport asking for LTA's assessment on the demand for bus services on the routes being plied by the special shuttle bus services at Marine Parade GRC. Even though his question asked for LTA's assessment of transport needs, his question was redirected to the Ministry of Culture, Community and Youth without his input. When he rose to ask supplementary questions which were transport-related, the Minister of State for MCCY was unable to answer them and instead invited the LO to file a question with LTA instead, notwithstanding the fact that the LO had initially done so. While the Minister for Transport did step in shortly at that session to address the LO's queries, the question still remains as to why a question posed to LTA was redirected to MCCY in the first place. Sir, question time is precious. Limited to usually 90 minutes per sitting, MPs compete to have their questions chosen for priority listing, failing which they either let it lapse for written answer or hope to have priority listing on another day. When a question is redirected to a ministry that cannot address the MP's concerns, the MP may face procedural objections to refiling it. Moving forward, could MPs be consulted on any intended redirection of questions so that our input can be taken into account? Next, on the reputation of Parliament as an institution that makes laws prospectively and with advance notice to the public before implementation. So to this end, I believe the recent episode of the Urgent Insurance Amendment Bill targeting the Alliance income deal may have dented Parliament's reputation. The Workers' Party expressed serious misgivings about the proposed acquisition of income insurance by Alliance, but we did not support the bill. As my party colleague Ms. He Ting-Ru had argued then, the legislation affected a live transaction and would undermine legal and business certainty that was critical to a business hub such as Singapore. In that debate, Deputy Speaker Christopher D'Souza opined that the bill was a hybrid bill. He explained that although the provisions of the bill were drafted in general terms, it was clear that the bill was, in substance, aimed at the proposed acquisition of income by Alliance. Ordinarily, the standing orders would require that such a bill be referred to a select committee for close scrutiny, since it affected prejudicially the rights of particular parties. But because a certificate of urgency was obtained, the select committee procedure was done away with. This deprived Parliament of the opportunity to hear from the affected parties themselves before passing the bill. So while the circumstances may have required it, such certificates of urgency should be deployed as a last resort. For example, the urgent bill could have been avoided had the lacuna in MCCY's regulatory ambit been identified in 2022 when income's corporatization exercise was approved. So this episode is a salient reminder of what is at stake: our reputation as a legislative body that respects the fundamental rights of the rule of law in the discharge of our responsibilities. Finally, sir, on the PCMR. In 1966, a constitutional commission was chaired by the then Chief Justice Wee Chong Jin, and it recommended the formation of the PCMR, which was established in 1970. Its role is to scrutinise bills passed by Parliament for any differentiating measures that discriminate against any racial or religious community, and if so found, to refer the bill back to Parliament for reconsideration. The PCMR was later entrusted with other functions as well. The Wee Chong Jin Commission had recommended that the PCMR members be chosen from distinguished individuals who did not hold any political affiliation. It also recommended that members serve for fixed terms that could be renewed. However, these recommendations were not adopted, and today the PCMR is comprised of 18 members, 5 of whom are appointed permanently and for life. I'm very disturbed, sir, that all 5 permanent members in the PCMR have been or still are cabinet ministers, including currently Senior Minister Lee Hsien Loong and the incumbent Minister for Home Affairs and Law. Of the 5, only Mr. Abdullah Tamuji and Mr. S. Dhanabalan received their permanent appointments after they left the cabinet. So the Workers' Party values the check that the PCMR could provide against inadvertently discriminatory legislation. However, most of the bills passed by Parliament are proposed by the government, and yet the bills are being sent for scrutiny by a PCMR consisting of life members of incumbent and former cabinet ministers. Is there not a conflict of interest here? I must confess to be perplexed as to why cabinet ministers need to be appointed to the PCMR. If it is the case that the PCMR would benefit from hearing from the government, the Prime Minister is already empowered to authorize any member of the cabinet to participate in PCMR meetings, albeit without a vote. Even so, it does not explain why they have to be appointed for life. Indeed, the PCMR is the only institution I'm aware of where some members serve for life. Would it thus not be far superior to keep the PCMR as a council of distinguished citizens who are non-political individuals on fixed terms, as recommended by the Wee Chong Jin Commission? Sir, we should aim to build institutions that will see Singapore through over a long period of time. Whether it or not it works today will not be indicative of whether it works tomorrow. And a system which entrenches the influence of members of former administrations until quite literally the day they die, in my opinion, is not a viable one.
Mr. Chairman, I thank the member for her cut. She had 3 points. One, on the way question time was managed, but essentially that cut was really focused on redirection of questions. The second was on the reputation of Parliament, but essentially that focused, I think, more on bills brought on an urgent basis, certificate of urgency in the specific context of the NTUC Alliance bill. And the third one was on the PCMR, or the Presidential Council on Minority Rights, which actually doesn't quite fall into the gist of the cut that was filed, because it says question time and the legislative process need to be safeguarded and strengthened. And I'm afraid, there was not sufficient indication that the PCMR was going to be part of that. But nevertheless, I will address the question as it has been presented. And if there are any further details that are needed, or if the member thinks it's not fully addressed, the member can let me know. So let me deal first with redirection. At the end of the day, what is the purpose of parliamentary questions? The purpose of parliamentary questions is so that members can ask questions about things and the ministers can reply. It is really for the government to assess and determine who would be in the best position to respond to the questions. And in some cases, MPs actually do address the question to the wrong ministry. For example, the Ministry of Finance frequently gets PQs on the Monetary Authority of Singapore. But Monetary Authority of Singapore reports to PMO, not to Ministry of Finance. So essentially, when the PQs come in, the Parliament will look at that. They will send it to the ministry that is named, And the ministry that is named will have to look to see whether this is under the ministry's purview or whether another ministry is best placed or is the policy owner or has the carriage of the operational aspects. So that is something you should leave to the government to determine. It's not really for the MP to decide who has the relevant knowledge. It's for the government to, looking at the question, to determine who amongst us, who amongst the agencies and the ministries is the one responsible or has the knowledge or is in the best position to respond. What is truly important at the end of the day is that the question is responded to. And that effectively is what is done. Because no matter who the question is redirected to, which agency or which ministry, there will be an answer provided. And if at the end of the day, the question from that particular, the answer from the minister or ministry is not sufficient, the MPs do have the opportunity to come back and to ask further questions in another PQ or on another occasion. I think in the example that Ms. Lim cited of the LO's PQ that was filed addressed to the Ministry of Transport asking for LTA's assessment, my understanding is that the bus decision in this particular case was made by People's Association, not MOT or LTA, and it was therefore not for MOT to explain why the shuttle bus was launched, because that was a scheme done under the People's Association. And People's Association is a statutory board that comes under MCCY, and that is why the Minister for Community responded to that. That said, I believe the Minister for Transport, Minister Chee Hong Tat, did rise to clarify a point from the Leader of the Opposition, as he had asked with respect to the bus connectivity enhancement program, and that comes under MOT. So because that one came under MOT, the Minister for Transport responded to that. So that deals with the first issue, which is on redirection. Then the second thing, on reputation of Parliament, let me just say at the outset that actually just bringing a bill quickly on the certificate of urgency is not the most important consideration when it comes to reputation of Parliament. For the reputation of Parliament, what is most important is that MPs conduct themselves with the highest standards of conduct, with integrity, do not mislead people outside as to what happened in Parliament, and also speak the truth to Parliament and its committees. Now, let me deal with the specific instance that Ms. Lim raised. Just find that. So the issue that Ms. Lim raised was bills which are presented on an urgent basis. Now, our system ensures that members do have sufficient time to review the bills and to debate them robustly in this House. Bills are introduced at prior sittings, and as a general rule, there must be 10 clear days between the first and the second readings of a bill. Hence, MPs generally have about a month to go through each bill, which forms the basis of the Minister's second reading speech. However, there may be situations where it's necessary for a bill to be brought for second reading at short notice. Hence, our system also allows for a bill to be presented under a certificate of urgency on the rare occasions when there is a need to do so. On the bills that were presented under certificates of urgency during this term of government, there was the COVID-19 Temporary Measures Bill and the 3 amendment bills thereafter, as well as the other COVID-related bills. Then we had the one that Ms. Lim talked about, which was the Insurance Amendment Bill in October 2024. The purpose of the bill was to allow the Minister in charge of MAS to impose conditions on an approval of an application to obtain effective control or become a substantial shareholder of a licensed insurer where a co-op is concerned. This was necessary because the proposed deal by Alliance was under active consideration by NTUC Income shareholders at the time. a long duration between the first reading and the second reading of the bill, and thus a delay in the amended law taking effect, would have given rise to even more uncertainty in the market and for the parties concerned. And Minister Edwin Tong had explained this context in his ministerial statement when the bill was introduced. Sir, we will always respect and uphold due process in this House to ensure fairness and maintain trust in our institutions. But from time to time, there may be exceptional circumstances, such as in the case of the Alliance Bill, that call for us to be an agile legislature so that we can best serve Singaporeans. Measures such as certificates of urgency have been and will continue to be used sparingly and only when necessary. I come now to the last point which Ms. Lim raised, which I understand really to be an objection to the fact that the Presidential Council for Minority Rights, the PCMR, has certain permanent members. Sir, there is value in having members who have long experience. There is value in having members who are also members of Cabinet because they provide a certain perspective. There are other members, of course, who come in, and those members may change, who provide other perspectives. But what we try to do, particularly with minority rights, is to have a wide spectrum and a wide range. And it is important to remember sometimes that there are things which were bills which were passed, legislative provisions that were made because of a certain historical context. Therefore, having people who remember that context, who remember the original situation in which a certain legislative provision was provided, or certain reasons why we did not put in legislative provisions, that is valuable and that is useful. So I can't see any objection to having the composition of the PCMR in the terms suggested by Ms. Lim.
Ms. Lim?
So how much time do I have?
I will give you some time, yeah, but I hope not too long. We actually are approaching the end of bulletin.
Okay, thank you, sir. I have three clarifications for Minister based on the three topics which I raised. First, on government deciding which ministry should answer the question, does the leader not agree that sometimes questions can cut across more than one ministry, and the MP actually would be the one to know what is the focus of the question? And therefore, is it not possible for there to be a procedure where there's some loop back to the MP to ask the MP, all right, we intend to redirect it to another ministry, do you have any concerns about it? And then at least our input can be taken into account. So that's the first clarification. The second topic I raised on legislative process, actually I think leader kind of missed the main issue, which was that, as pointed out by the Deputy Speaker at that sitting, the Insurance Amendment Bill was a hybrid bill that directly affected particular parties. And under the standing orders, it is supposed to be the norm that if there are such bills, then a select committee has to be formed so that Parliament can hear directly from the affected parties on how the proposed bill would affect them. And in this situation, you know, we're talking about a really important social issue, and the MPs were deprived of that opportunity to hear from the parties because the certificate of urgency was issued, and therefore the bills were just passed without the select committee procedure being activated. So I think to that extent, Parliament has been prejudiced. Last of all, about the PCMR, actually what the Minister answered was already, preempted in my speech, because she said that having members with knowledge of why particular bills were passed or the legislative history would be helpful to the PCMR. But the Constitution already provides for the PM to appoint ministers to attend the PCMR meetings, to give that perspective to the PCMR members. So there's no need for ministers to be members of the PCMR for their voices to be heard. So does she not agree with me that actually the system design, if PCMR is supposed to be an independent check on legislation, having ministers on the PCMR actually doesn't look quite right?
On the PCMR, I'm not sure that PCMR is set up as a check on the legislature. it is set up as a check to ensure that minority rights are addressed or thought about. And whether you appoint or whether they are permanent members, the point is that they have something valuable to contribute. So I don't see the objection to having permanent members. Then the second point on the legislative process and the Insurance Amendment Bill, I do take Ms. Lim's point that in the normal case, it would go to a select committee, but the standing orders also do provide that in an urgent case, then it need not go to a select committee. In other words, when the standing orders were designed, it was thought about, and you do realize, I mean, you do anticipate that there may be situations that are urgent, because when you go to a select committee, it takes time. And in this particular instance, given that there was concerns with the market, as I've explained, there was urgency to do it. And that is why a certificate of urgency was brought. So in other words, it is not that every day we have urgent certificates. In this particular instance, there was a need to do it quickly. And that was already explained by Minister Edwin, so it's unnecessary for me to go into that detail. And then on the last one about redirection, I think we would not want to put in place a process where every single question that is filed, you have to go back to an MP and check what was your underlying intent. I mean, really, members of Parliament, when they file their questions, should make their questions clear. Now, if in the situation that Ms. Lim describes, where it is redirected and the member feels that it should not go because the underlying intent was to ask the other ministry something, the member is always free to reach out to the relevant minister and explain that. Actually, usually what happens is when we get a PQ that is not very clear, usually the ministries or one of the, either the SPS or the Minister of State will reach out to the MP to ask, what exactly are you asking here? There have been cases when we've had to do that because the intent of the PQ is not clear. It doesn't happen all the time, but sometimes when it's ambiguously worded, we do. And then in that instance, once we ascertain from the MP what is the real intent, then we can decide whether to leave it with one ministry or to redirect it to another. But on the face of it, questions ought to be clear if they're properly drafted. And if it's clear and it appears to us that this falls under the purview of a particular agency or ministry, we would redirect it accordingly. And like I said, it's not as though the MP has no chance to come back and file a clearer PQ directed at the ministry or agency that the MP wants. So the MPs are not shut out.
Ms. Lim, would you like to withdraw your amendment?
May I just make two quick points, sir?
A very quick one. We're actually out of time. Yeah.
Thank you, sir. Thank you, sir, for your indulgence. Just to respond that under the standing orders, an MP may be precluded from filing a question again if it is deemed to have been fully answered. So that decision, sometimes there's a tussle between the relevant officers and MPs about this. And last of all, regarding the urgency of the Insurance Amendment Bill, I just, of course, to note that the deal has been aborted. So I do not know whether the parties felt that they were inadequately listened to. So I do not know the answer to that. But sir, in any event, I mean, there are clearly many interesting issues that we can talk about about Parliament and its functioning. And I would hope that there's common cause that all of us want Parliament to be effective. And with that, sir, I beg leave to withdraw my amendment.
A very quick response. The first point you made, what Ms. Lim made, was that because of the standing orders which says that if a question has been answered fully, then you cannot bring it again. But that's the point, because if the MP felt that this was supposed to be addressed to another ministry, it must follow that it's not answered fully. So then you can direct it to the other ministry. And with respect to the last question, when she raised the issue about the bill being aborted and what is the response. Now, this is a classic example of a question that should not be directed to me. That should go to Minister Edwin Tong. So if the member has any clarifications on that, that's something to be directed to Minister Edwin Tong.